Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
21 minutes to 12 on 882 6PR. Get your questions in 133 882 or 0487 999 882. The great Nick is sitting opposite me. I love it when I've got access to a free legal mind. It's fabulous. Now, Nick, this morning we were discussing the ownership of beaches in Australia, and we were all putting forward what we thought, and we didn't think that anyone could actually privately own a beach in Australia. What's the actual sort of overarching legislation, as it were? Is there a piece?
Yes, so that's right. So basically the fundamental principle is that beaches are owned by the Crown land, right? Mm-hmm. So they're owned by the government, and the beach really starts at the high water mark, so that when the tide is at its highest. And the WA Planning Commission, which regulates planning laws in WA, has got a policy on this. They've got a coastal planning policy, and they really regulate how this all works. And this policy makes it really clear that you can't have private residential dwellings on beaches. It makes it clear that, if you have any squatter shacks, they have to be removed. You can't have any wastewater infrastructure, and you can't have any permanent infrastructure like sewage and draining and stuff like that. And this policy really regulates what's allowed on beaches. And they also say it also provides restrictions on development within 300 metres from the beach. So that's kind of where the policy really kicks in. They want to ensure that the public has access to the beach and it's not blocked. The policy also deals with views and stuff.
All right. So then how come this farmer down in Busselton Way, has got a private beach? Why are there a couple of private beaches around?
Well, so my best understanding would be that they would have got a license or a lease of some sort before these laws kicked in, right? So these policies really, this policy I'm referring to started in 2003. It's been developed over time, but old English law says that you can own property up until the part of the beach where the high tide touches, right? Okay. So maybe there was, historically, they did get something, and they just held on to it. But right now, as of modern times, there's really restrictions. I mean, you can build stuff like surf life-saving clubs, and you can build like barbecue toilets and stuff like that. There are restrictions on community buildings on there, but you're not going to see anyone. It's very unlikely, unless someone who's really clever and cunning, that they're going to get any sort of private dwelling on a beach in modern times. So I think the person that has got that license or lease, and I'm expecting that to expire as well, right? So there would be an end date that will come down to. They just got lucky, and it was olden days.
Yeah, just in the right place at the right time. And you happen to have a block on the beachfront as well. There's people to fight for that right back then, one would suspect. Nick, what about people who live in the river? You see the private land use down to the river. Is the river covered the same way, do you think?
I would expect that there would be, this policy deals with coastal specifically, but there would be similar policies as well, because access to the river, it would be treated the same way. It's for public use, and there would be different types of restrictions about boundaries on how far you can build. Natural
land frontage, so canals again are different in a different way. You've got a question this morning, or are we this morning? We are still on this morning. Goodness me, Christina. 133 882 if you'd like to join us. Julie just wants to jump in and borrow your brain cells at the moment, sir. Hello, Julie.
Hi, Christine, Nick. Just a quick question. We bought a new TV in the sales, and we specifically said that we have a very, very bright room. So during the day, if we've got the TV on, we need to be able to see the screen. So we bought a $5,500 TV, got it home, wonderful picture that night, but during the day, the reflection from all of our lights, you just can't see the screen. So I rang them, and they said, email us some photos, and then they said, no, we don't have any recollection of that conversation. And so now we've got a $5,500 TV that we can't really watch during the day. So I'm wondering if there's anything that we can do further, or that's just their policy, obviously. Once the box is opened and been used, it's like a week old, and you really can't watch it during the day.
Yeah, so Julie, I think that you potentially have a case there. So when you're purchasing something and you expressly tell the seller, I need it for this person, and the seller, here the salesperson tells you, yes, it does fit the purpose that you use it for, and they give you assurances, they give you representations that this TV can work well in the daytime and the glare issues, and they made those representations to you, then they're bound by them. So under Australian consumer law, you are entitled to a refund. In this case, the difficulty comes down to proving it's a he said, she said situation. So you obviously have in your case, this salesperson probably has lots of discussions with many people. Surely they can't remember every discussion. But if you have a witness, did you have a witness present with you, or was it just you?
Yes, my husband, yeah.
Great. So you got two people there verifying what was said. So you'll write to them and you'll explain to them, look, Australian consumer law, you made these representations. I want the refund. So you try and get see as far as you can get with that. Then the next step would be to go to the magistrate's court. You can commence a minor case claim, or you can commence a consumer trader claim. If your claim is less than $10,000, you're not going to get court costs awarded against you if you win or lose. You might have to pay the small filing fee issues, but you won't have to pay their legal costs. So you can just start a claim there. Before you get down that path, you might want to fill out this magistrate's court, a minor case claim form, download it and send them a draft version of the form and say, look, if you don't kind of give me what I want here, I'm going to file this. That might scare them a little bit into taking action.
Yep.
But I do feel that based on the representations you've made, if those representations are untrue, I feel that the case is there and it's worth pursuing. And when you start court proceedings, if you do, don't be too scared. You're not going to go to a trial straight away. The court will push you to a mediation where they'll get the representatives of the company there and you'll be there and you have a chat, and that's where most cases settle. So, that's kind of the process you can go down through. Just those words, representation, those words, Australian consumer law, they're the ones you want to throw in there.
Do you have the time, Julie, to do that?
Yes, I do, because I'm not watching TV during the day now.
Sarcasm. Love it, Julie. Best of luck. Let us know how you go with that one. You're listening to Law Talk with Nick How do I say your last name again?
Maruchak.
Murachak. Where is Murachak from again?
It's Ukrainian.
Pardon?
Ukrainian.
Oh, nice. Okay. We've had that discussion before, but I'm like a goldfish today and I've forgotten. We're going to go to a quick break and then come back with more of your calls. 133 882. We're going to talk about medical decisions for older Australians and people who may be incapacitated in any way in a few moments. Before we do that, Arnie has texted you in, Nick, to say, law question, can I get charged overseas in another country for insulting and defaming someone over there if I'm sitting here in Australia and insult, defame them online? Arnie, what's your mother told you? Never speak nastily about other people. All right.
Yep. I'd recommend, first thing, just don't defame anyone. Don't insult anyone. That's the safest way, because you can get in all sorts of trouble. The thing with overseas law is that the world's a big place and we don't know exactly what laws apply in every country. So it could really surprise you. There could be a law in America that says, yep, you can sue someone over here. But when it comes, so don't do it. When it comes to defamation laws, though, in Australia, if you post something online, someone can sue you in a place where that material can be accessed and read, right? So if you post something on Facebook, it can be read in every single state, and then someone in New South Wales can then sue you. And all the defamation laws are state-based, but I will just say this, in New South Wales, they tend to have much higher damages awarded for defamation cases. So in WA, you might get $5,000 if you win. In New South Wales, you might go up to $50,000 or $100,000, right? So it's always better kind of suit in New South Wales than in WA. So stuff online that because it can be read everywhere, exposes you to that. And also, if the defamation is serious enough, under WA law, you can actually be done for criminal defamation. I once tried to get the police to take action against someone for criminal defamation because they called my client a pedophile. Police weren't interested, but the law's on the books there as well. So that could be, yeah.
All right, Arnie, hope that helps you, but try and be a nice human being to start with. That's an easy way to go. Now, you and I have been trying to talk about this subject for a while. We've got 4 or 5 minutes up our sleeve, and it's to do with the power of, do you call it a power of attorney for people who are
So when it comes to power of attorney deals with finances, right?
Okay.
So it allows someone to manage your finances. But another one is an enduring power of guardianship, right? So this document you can appoint someone to make lifestyle decisions for you, personal decisions, and medical decisions for you, right? So if you can't make medical decisions for yourself, right, and you're in a coma, what happens? Who can make those decisions for you about your medical treatment? So, that's something I'd love to talk about, and how it all works.
All right, tell us more.
So if you have there's first thing, this is how it kind of works. The first thing you can do is create an advanced health directive. Now, this is a document that says that you basically write down everything you want about your future medical treatment. Mm-hmm. So you can write down, if I'm in a vegetative state, I want them to pull the plug. You can put stuff in there about what kind of medical decisions you want made, right? So you make it in advance. And the only time that can really get overturned is if the doctors come in and they go, well, you've kind of made a bad decision here and it wasn't possible to you to foresee. We have some new treatment here, so we might overturn it, right? So there is a little bit of an out there, but that's the first thing they do. If you don't have one of those, then there's something called enduring power of guardianship, which is basically you appoint a person to make those medical decisions for you, and if they're available, then that's the person that will apply. If you don't have either of those two things, then there's an actual hierarchy of family members. So the first person that gets the pick, if they're available, is your spouse or partner, right?
Okay.
They got to be living with you though. So ex-spouses don't get a say here. You've got to be kind of living. Then the next kind of order.
Well, even if you're if you're not divorced from them, because I know there's another ruling, isn't there? If you haven't divorced from someone and they keel over backwards, and there's no.
Well, yeah, they're in your will, right?
Yeah.
So it's not in your will. So if you don't have a will, then they get your estate, right? If you die without a will. But with these laws for medical decisions, they kind of say the spouse has to be living with you. And I like that.
Okay. Yeah.
Because then it's like if you're separated from someone and they're technically still your spouse, at least they don't really kind of have a say in your treatment because they might want to turn the plug off, right?
Right, because you haven't written the will. That's right. Yeah.
They might want to do that. So and then this all will happen really quickly, right? Because this is a medical situation and things are time paramount. So then the next list is a child over 18, then it's a parent, and then it's a sibling, and then they go into like anyone has a close relationship with you, has regular contact with you, and then it's a carer. So that's kind of how it all works if you can't make decisions for yourself.
So can I download that or I have to go to a lawyer?
Oh, you can just download that, like just Google who makes medical decisions for you. It's in the Guardianship and Administration Act.
And file it with again?
Pardon?
File it with?
Oh, so yes, with the prepare an advanced health directive and prepare an enduring power of guardianship and just hold it on. You don't have to file it anywhere, but just hold on to it and make sure your family members know about it.
Does it have to be witnessed by anyone in particular?
It does. It has to be witnessed by a justice of the peace.
Good. Otherwise someone could do it. Anyone could do it. All right. Nick, it's been a ride. It's been informative. Thank you very much for your time today.
Thank you, Chrissy.
Nick Maruchak doing a bit of law talk with us, and we'll be back again next week. You're listening to 882 6PR.